I'd like to apologize to the House for being a bit late this afternoon. The House is resumed. Does any other member wish to speak? Does any other member wish to speak or recognize the Honourable Leader of the Opposition?
Thank you, Madam Speaker. Madam Speaker, firstly, let me say that the reason I took the matter up to put a motion was not to try to give the government a hard time, because I'm fair. I'm a fair man. This government had nothing to do with the court ruling. It had nothing to do with the court ruling. My contention is that the judge's interpretation is wrong. And I sought to get the government to see how they could rectify it. That's what my motion was dealing with. The government picked it up. And yes. To me, Madam Speaker, it's absolutely clear what a health practitioner is. A health practitioner is different than the employee. From my understanding, from my knowledge, my belief, a health practitioner is different than the typist, the cleaner, the board member. Health practitioners are registered according to the law to practice. The employee is different, as far as I'm concerned and thought, in definition, as they are not registered to practice. Madam Speaker, these laws go way back. The law was passed in 1974. Then in 2002 was a new law. Then there was an amendment in 2004, and I think one again in 2013. And it's gone through three governments, from 2005, the PPM, 2009, the UDP, 2013 now. So it's roughly three governments that we would have dealings with. 4. Yeah. That was a long time, Madam Speaker, from 1974, but certainly it is 12 years now for the present bill that we are dealing with. One thing is certain, Madam Speaker, I would always do what I can to protect people who are the employees in this instance, and I would protect people who give of their time and resources. Madam Speaker, this clause goes way back. I believe there must be something like, when we looked at it, there are several laws with the same clause or something similar. There is the think the National Roads Authority law, the Airports Authority law, the Development and Planning law, the Monetary Authority law, the Maritime Authority law, the Water Authority law. 1, 2, 3, 4, 5, 6, 7 laws, I believe, that has that clause or a similar clause of protecting the workers, meaning employees, not meaning, well, in those instances, they don't have, and board members, protecting board members. And I believe, Cayman Airways, we gave a blanket one too. Yeah, and that's where I contend. I believe that I can do that, or I should be willing, and I would look at doing that and support that, but I couldn't and never was in my mind to vote on a bill to give anyone such immunity. And those are two different words that I see that catches my attention and as it stands, because I never ever heard about this coming up before, except for that case that brought it to the forefront. As I said, 4 or 5 governments went through, and we never had no problems with it. So even if we had to give an indemnity, and as I said, these laws have indemnities. I don't think there was any immunity as such, but certainly the health services law, I don't believe was meant to do that. As I said, the health practitioner's law of 1994, 74. Sorry, yeah, the practitioner's law 19 of 1974, revision of 1995, says health practitioner means a person registered as being authorized to practice in one or more health professions. Must be talking about doctors, people who do that kind of work, not talking about typists and so on, and the people who clean the floors or people who sit on the boards. To my mind, the employee is different in definition. They are not registered to practice. As I said, Madam Speaker, what happened in court was the judge's interpretation. And as we know, that is always subject to an appeal. One lawyer says something, another lawyer says something else. If it goes some court says something. If you not stop there, you go into Grand Court, and he says something else. And after that, then there's the appeal, and he says something. And then you go to Privy Council, and they say something. So everybody has say, and not everybody is of the same mind. One judge as against the next one. That's why you have the appeals. But as far as I'm concerned, Madam Speaker, there was not, to my knowledge, any such intention by the minister at the time, and most of all, there were no such policy by the government to make someone not be able to stand responsible for something that they did happen in the course of some kind of treatment. And so I want to take time, Madam Speaker, to read the debates. The First Amendment, I think, was the 27th of October by the then minister. The Health Practitioners Amendment Bill number 2, Amendment number 2, Bill 2004. Mr. Gilbert A. McLean, introducing the bill. 2004. Well, I'm reading from 2004. I know, but you don't. You had your debate, so huh? I know what you try. I can read that too. I can read all of them. Every one I can take the time and read, Madam Speaker, because we need to get the full picture. And then, that's right. But I got the 13th of December 2004, and I got Thursday, June 27th, 2002. But let me agree with the Premier and yes, and read some of what was said here. That was the creation of the bill, 2002. Mr. Gilbert A. McLean again. And he said, and I quote, "Neither the authority nor any director or employee of the authority shall be liable in damages for anything done or omitted in the discharge of their respective functions under this law unless it is shown that the act or omission result from their dishonesty, fraud, or willful neglect." So, talk of the legislators giving some immunity is not so. There was no such law and no such intention and no such policy by the government then. Come to October 27, 2004. Mr. Gilbert McLean, members of this Honorable House would be aware that the Health Practice Law 2002 grants the Ministry of Health Services the authority to ensure that the health of the public is protected through regulation of health professionals and institutions in which health services are provided. Members will also recall that the Health Practice Commission was recently established to carry out regulatory functions as outlined in the law. The Commission was advised that health practitioners who are members of the Medical Protection Society could be in breach of the law because the society is not an insurance company and does not offer malpractice insurance coverage. Most doctors in the Cayman Islands are members of the Medical Protection Society of the United Kingdom, and certainly all those at the Health Services Authority are members of that particular society. After receiving legal advice, I accepted the Health Insurance Commission's recommendation to amend the Health Practice Law 2002, permitting it to be legally acceptable and sufficient for health practitioners in the Cayman Islands to have medical indemnity. Section 52A of the Health Practice Law 2002 requires a person operating a healthcare facility to provide malpractice insurance for employed practitioners. The bill laid on the table of this Honorable House would amend this section to allow an operator of a healthcare facility to obtain as an alternative to malpractice insurance and indemnity cover approved by the Health Practice Commission for registered practitioners employed by the healthcare facility. The bill also seeks to clarify that malpractice insurance, liability insurance, medical indemnity, and any other insurance required by the law shall be obtained from an authorized insurer. So, Madam Speaker, if there was any intention to not provide or not to give them any immunity, why in the world are you making sure that they have malpractice insurance? This bill achieves the objective of ensuring that the public is protected while allowing practitioners to access cost-effective malpractice insurance coverage. This bill is one which, to my mind, is extremely straightforward in what is attempting to achieve, and I recommend the bill to the honorable members. Thank you. Now, Mr. Kurt Tibbetts, then leader of the opposition, rose to speak, and he said, Mr. Speaker, in listening to the Honorable Minister for Health presenting the bill, it seems to us on this side that it is fairly straightforward. There is a point that we would like to make sure that we are very clear on. The amending bill refers to Section 15, where in the amending bill it reads, the principal law is amended in Section 15 by repealing subsection 2 and substituting the following. And with your permission, I just want to refer to subsection 2, which exists in the current legislation, Law 25 of 2002, Section 15.2, speaks to a person who operates a health care facility. A person who operates a health care facility shall provide malpractice insurance for the registered practitioners employed by the health care facility. This is Mr. Tibbetts saying that. Continuing, he says, the way the law reads now, it is the person who operates the facility, the health care facility, who shall be responsible for providing malpractice insurance for the practitioners employed by such facility. What is being proposed here is that a person who operates a health care facility shall provide malpractice insurance or indemnity cover approved by the Commission for the registered practitioners employed by such health care facility. Subsection B of the proposed bill speaks to that individual ensuring that the health care facility is covered with adequate liability insurance, and subsection C says that that individual must ensure that persons who work at the facility under a contract of service with the healthcare facility have adequate malpractice and other relevant insurance. What is being proposed, as we understand it, gives the individual an option for the practitioners who are employed by the facility. The existing legislation does not provide an option as we see it, because the existing legislation speaks to the individual who operates a healthcare facility. It says, shall provide malpractice insurance for the registered practitioners employed by the facility, whereas the proposed bill speaks to provide malpractice insurance or indemnity cover. We would very much like for the minister to just clarify that point. I heard what he said in presenting the bill about not being able to provide such coverage, but the onus now is shifting from the malpractice coverage being provided by the individual who operates the facility. If we look at the proposed subsection C in the amending bill, it says that such persons shall ensure that the persons who work at the facility under a contract of services with that facility have adequate malpractice and other relevant insurance. Therefore, as we understand it, instead of the operator of the facility providing malpractice insurance for the practitioners who work there now, it is now saying that the operator must ensure that these people have adequate malpractice insurance or other relevant insurance. It seems to me that there is also a question of malpractice insurance and indemnity cover as to what the cost of each of these are and the availability of each of them. Mr. Tibbetts goes on, perhaps in the minister's winding up, if he has the information available, to just expand on that a little so that we are very clear understanding what he has said, but so that we are very clear with regards to once this is approved and becomes a part of the existing legislation, where the responsibility lies. Because we do know that while such insurance is absolutely necessary, we certainly want for all parties to be properly covered and to ensure that if anything goes wrong, that everything can be sorted out, because each side of the coin is covered properly by whatever insurance is necessary. Doesn't sound to me like it was meant for them not to have insurance, or they were giving anybody indemnity just so they could, if anything happened, nobody could sue them. Doesn't sound so to me. Anyway, he goes on to say, again, just to make absolutely sure, I do believe the way it reads is that if the operator of the facility is to ensure that the people who practice at the facility have proper coverage, it does not clearly say as to who is responsible for the payment of the coverage. I do not know whether the objective of the legislation is to be clear as to who shall be responsible for the payment, or whether that is not a consideration for the legislation, and that is a matter that one should sort out on his own as an operator or as a practitioner. An operator meaning the owner of the facility. Cayman Islands Hospital, whatever hospital, and the nurse, the doctor, whatever, not the cleaner, not the typist, the practitioner. But he continues, I do see, unless that is made clear, a potential problem with regards to people being employed as to where the onus lies. Perhaps we would want to give some consideration to that. Mr. Speaker, I'm assuming that this law also applies to any government facility. I do not presume for a second that government is exempt from this legislation. So perhaps the minister could just, for information and for purposes of clarity, just give the House a quick explanation as regards to how government will be operating under the guise of the new legislation once it is approved. Those questions were simply just a matter of clarity. Mr. Tibbetts continuing, we certainly understand the intention of the bill, and we support that intention, but we would like if the minister would just clarify those issues so that we are all clear as to the way forward with regards to the entire process and the vote. You understood it? How he says? Mr. Gilbert, in winding up, Mr. Gilbert A. McLean. Thank you, Mr. Speaker. The minister now is explaining. Honorable members of this House will understand clearly what malpractice insurance is supposed to provide. It is a requirement that is put in place where if a doctor, through misconduct or mistake or whatever, should injure a patient whom they are supposed to help, the patient should have the right to sue for damage. And the medical practitioner should be in a position to pay the cost of those damages, and this is done by way of malpractice insurance. It is a term that is regularly used that we are familiar with, which stems largely out of the United States. We have heard of major settlements in malpractice insurance. Of course, in the United States, there are so many lawsuits that a certain percentage of doctors are stopping the practice of medicine simply because they cannot afford the premiums anymore. They rather simply not take the risk, so they get out of the profession. Others publish on the door a notice, we do not have malpractice insurance. Is an option there to have it or to not have it, and the public should notice, not that it hinders them from being sued, but I think it is a consideration that is given in any such litigation if it was a published notice and someone going to that person knew that they did not have malpractice insurance. In meetings with the representatives of the Cayman Islands Medical and Dental Services, there were those who attempted to persuade me not to put this requirement into law. That requirement is so that they have insurance. I was not persuaded, he said, in that regard, because I think that it is better to have that requirement in the law, as incidents do happen, and it is better that the doctors are covered and the person who may have to sue for damage knows that he is not suing a medical practitioner. Not, again, Madam Speaker, I got a doggone thing to do with the typist, the boardman, or the cleaner, or the gardener, or the cook. No. All to do with a medical practitioner who has to be registered as such a medical practitioner. Mr. McLean goes on. And the person who may have to sue for damage knows that he is not suing a medical practitioner who can declare bankruptcy or does not have any coverage or money to pay them. It was put in the law for those reasons. Now, what I came to discover was that all of the doctors at the Health Services Authority, HSA, are covered by the Medical Protection Society of the United Kingdom. It is in fact an organization which serves doctors across the Commonwealth, and the government has been paying the fee for this coverage for medical practitioners. I inquired into that situation, and I learned that that society, in effect, paid for and defended practitioners when they decided to take actions against government or the HSA, as the case may be. There were about 2 or 3 cases like that. I thought it was fundamentally flawed for anyone or any entity to be paying or picking up the tab so that somebody could turn around and sue them. It was after learning about this particular situation that I asked the legal drafting and the staff in the ministry to look at a way forward in this regard. What is possible now and would obtain now if the government continued to pay the coverage for the doctors who work at the HSA, that coverage would not be allowed by the society to be used to take action against the management of the HSA. It would cover the doctors in the practice of medicine, but it would not cover them if they wanted to take action against their employer. They would have to go and pay for that themselves. So, the way the law is worded now places the responsibility on the HSA or any person who operates a health facility, because they shall see to it that they provide malpractice insurance or indemnity cover approved by the Commission. We ran into a flaw, and the legal people found that the indemnity offered by the Medical Protection Society is not malpractice insurance, as malpractice insurance goes. Therefore, it was necessary to amend the law in a way that doctors on a whole in this country could continue to get the benefits of coverage by the Medical Protection Society or malpractice insurance specifically, if they so choose, if it had the option of one or the other. It is my understanding that for them to get the malpractice insurance here, it would be exceedingly high and makes more sense for them to stay covered under the Medical Protection Society. Sections A, B, and C basically speaks to this requirement by anyone who offers health services or who operates a health care facility. Whether or not the doctors themselves are asked to contribute would be a question of policy. If a facility chooses to go and say to that person, look, you are covered, we initially will pay for it, you pay us back. It is an option, but it is a policy decision. The operator would have to see that the insurance was in place, whether they paid for it and it became a part of their administrative expense, or whether they asked the doctors to contribute. It will be left up to them to work that out among themselves. That is the objective in this amendment that is before the Honorable House. And I guess it would sail under the big umbrella of malpractice insurance, although we also have in this the concept and the term indemnity cover, which can be and is offered by the Medical Protection Society. Mr. Speaker, I trust that the explanation has been sufficient for the member raising the subject, and I recommend the bill to the Honorable House. As I said, I don't see, Madam Speaker, how anyone can declare that the doctors were exempt. How? Maybe, I don't know if the Attorney General has any other opinion, or anybody else, but from what Mr. McLean said, had to be what he meant. That was the 27th of October. Now, December 2004. Well, is there a difference between indemnity and immunity? Yeah, right? When you give them immunity, Madam Speaker, isn't it so that you give someone immunity, you can't do nothing to them, right? Yeah. Right. But this wouldn't give no doctor any immunity. Where, yeah, well, let me keep reading then. Not that I know about any immunity. What it was here is the word employees. That's where the judge got stuck on. But let's read it. Gilbert A. McLean. Thank you, Mr. Speaker. Over 2 years ago, I stood in this Honorable House and proposed to establish a health services authority as a long-term, flexible framework for an organization aiming to provide the high standards of patient care for the people of these islands at the best possible cost. Changing the Health Services Department and Authority was not a panacea. It has not solved all the problems or completely eliminated the spiraling cost of health care. However, Good things have and continue to occur as a result of this significant organizational change. The key to creating and sustaining a successful 21st century organization is leadership, not only at the top of the hierarchy, but also throughout the entire entity. During and after the passage of Hurricane Ivan, the benefit of giving greater authority and decision-making power to healthcare workers, that is, the persons who have direct contact with patients. And you note that the Blackstone's position talks about healthcare workers too. That's what they talk about. Keeping the Cayman Islands. During and after the passage of Hurricane Ivan, the benefit of giving greater authority and decision-making power to healthcare workers, that is, the persons who have direct contact with patients, was very evident. It would be remiss of me if I did not take the opportunity to again publicly commend Mrs. Eloise Reed, Chief Executive Officer, and the staff of the authority for their outstanding work in keeping the Cayman Islands Hospital operational under extremely difficult circumstances. Like any other private entity, the Health Services Authority has a board of directors that is responsible for the policy and general administration of the affairs and business of the organization. Board members who hold office at the pleasure of the governor and cabinet carry a heavy responsibility, both to the authority and to the public which they serve. The time and energy required of board members is substantial and the remuneration is small. It is therefore vital that we do everything possible to minimize the risk of personal liability of persons willing to volunteer their time and skills to serve on boards. Now he's talking about board members. That's the indemnity that was given to them that he's talking about. The bill proposes to amend the Health Services Authority Law 2003 revision to change the immunity provisions of the law as well as to provide an indemnity section by repealing Section 12 and substituting the following section. Neither the authority nor any director or employee of the authority shall be liable for damages for anything done or omitted in the discharge of their respective functions or duties unless it is shown that the act or omission was in bad faith. After Section 12, the following is proposed to be inserted at 12A. The authority shall indemnify a director against all claims, damages, costs, charges, or expenses incurred by that director in the discharge of his functions or duties, except claims, damages, costs, charges, or expenses caused by the bad faith of that director. The bill also amends Schedule 1, which so this went on to deal with another matter, Madam Speaker, but that was substantially his presentation on that matter. And in this, Madam Speaker, the minister at the time did not say a word about giving any or taking away any immunity from the doctors. But the law doesn't say that. Well, then that was your interpretation too then. Yeah. 12 years later, he agreed with you then. Well, I don't know. Maybe both on it right. I don't know. But I can say this, that was not the intention of the law. And the minister, if that was the intention of the law, I believe the minister would have said that absolutely clearly. He would have made it absolutely clear. That's what. But Mr. Tibbetts spoke. And what basically he was talking about, Madam Speaker, was the commission of bad faith, which he said was a sweeping statement rather than the other things that had been in it. But it didn't change the substance of the law. Then Mr. McLaughlin, then, now Premier, he went on to talk about those two things. But he too didn't say anything about immunity, doctors and immunity, healthcare workers, not that I see. Where you say that? I know you went on to talk about the director. He said, my colleague, the leader of the opposition, did read both the current and the proposed replacement section. This is the Mr. McLaughlin, who was a member of the opposition and now the Premier. The leader of the opposition did read both the current and the proposed replacement section. He pointed out correctly that the current section 12 provides that no director or employee of the authority shall be liable in damages for anything done or omitted in the discharge or purported discharge of their respective functions under this law, unless it is shown that the act or omission resulted from their dishonesty, fraud, or willful neglect. The proposed section 12 again says that neither the authority nor any director or employee of the authority shall be liable in damages for anything done or omitted in the discharge of their respective functions or duties, unless it is shown that the act or omission was in bad faith. As the leader of the opposition has pointed out, no explanation has been given to this Honorable House as to the distinction between bad faith, which is the proposed change, and dishonesty, fraud, or willful neglect. Personally, I would have great difficulty, particularly knowing something about the background of this proposal, to amend the law at this stage to give the directors and or employees of the authority additional protection and indemnity by the government by changing this subsection. The result of providing immunity or indemnity to the directors of or employees is essentially saying whatever you have done, as long as it was not in bad faith, the government will become financially responsible. If employees and directors have done something which is, to use current words of the section, dishonest, fraudulent, or willfully neglectful, then in my respectful view, they ought to be held liable for it. Yeah, but you talking about what? For who? For who? Employees who? Employees, listen, there's a difference between employees, and I know it too. No, I don't. No, we're not going to grow. I can just read into the Hansard, right? The law says who is a practitioner. No other employee had to be registered as a practitioner. It's clear. Now, he says, the judge says there's ambiguity in it, and I think Blackstone said there's ambiguity in it, and maybe because of all the way it's surrounded, there is some ambiguity. Certainly that's why I want it to be absolutely clear. That's why I moved the motion, or has the motion to move. But he was here talking about a contract. That's what the Premier was talking about. He went on to talk about that contract and a potential lawsuit from one of the, not a medical practitioner, but one of the employees. That's what he was talking about. And it's here in the Hansard. He said this is an extraordinary contract, the highest sum I believe ever to pay to a public servant in these islands. He's talking about employees, yes, but who? Who? And Dr. Frank, my good friend Dr. Frank, said that the role of the opposition at the time was to make everything that is clear cloudy. And in particular, my good friend, the second elected member from Georgetown, always likes to suggest that there has to be some dishonesty on the part of government and its members. I remind him that his understanding will also suggest that bad faith is dishonesty, bad faith is fraud, and that bad faith is willful neglect. California. Madam Speaker, I don't see how anyone reading this couldn't get the impression, and how anyone could interpret that what the minister said about the amendment, that he is proposing that it gives the doctors immunity. Can't be, Madam Speaker. Can't be. Madam Speaker, I must find the bill. Madam Speaker, here's the health practice law. Health practice law 2013. And in 15.1, it says, a person who operates a healthcare facility without a certificate commits an offense and is liable on summary conviction to a fine of $50,000 and a future fine of $10,000 for every day during which the facility is operated without a certificate. 2, Section 2 of the law. A person who operates a healthcare facility shall, 2A, ensure that the registered practitioners practicing at the healthcare facility have malpractice insurance or indemnity cover approved by the Commission. 2B, ensure that the healthcare facility is covered with adequate liability insurance. And 2C, ensure that persons who work at the facility under a contract of services with the healthcare facility have adequate malpractice and other relevant insurance. And such malpractice insurance, liability insurance, indemnity cover, and any other relevant insurance shall be obtained from an authorized insurer. So, Madam Speaker, here is no immunity in this healthcare law. None. None. Now, why didn't the judge look at that? I don't know. Why? Well, I know, I got asked. I don't know. Huh? I'm talking about the case that I wanted something done about. That's what I'm talking about. Whatever else to do, I don't know. I'm talking about the ruling he gave, which I said he misinterpreted. And here, this law clearly defines that two categories of persons exist: the registered practitioner and persons who work at the facility. That's what this law, Health Practices Law 2013, says. And in 27A, 2 sections of this law, it says, a registered practitioner shall only practice as a practitioner while he is in possession of a valid practicing license issued to him by the council in the prescribed form or payment of the prescribed fee to the registrar. 27A2, a practicing license shall be valid for a period of 2 years, commencing on the date of its issue or reissue, as the case may be. 27A3, the council may, upon the recommendation of the governor, waive the prescribed fee payable by a registered practitioner who is in full-time employment in the government service, if the council is satisfied that the registered practitioner is not also engaged in private practice. And 27A4, a practicing license shall not be issued to a registered practitioner unless the council is satisfied that the registered practitioner has adequate malpractice insurance, liability insurance, or a relevant insurance or indemnity cover obtained from an authorized insurer and approved by the Commission. So this law clearly requires it. And I say that my understanding of what was done in 2004 did not give them any immunity. And here, the law in 2013 revision clearly states that they must have it. Does not take away any need for them to have that or the requirement for them to have it. So, Madam Speaker, as I said, 4 governments went through, and until now, we were all unaware that such an all-encompassing clause exists in the law. We understand that the board of directors at the time of the coming into existence of the HSA was concerned about the liability in their personal capacity for the decisions and or actions taken by the board, and whether they were entitled to some form of protection from any liability where decisions and actions were taken in good faith, as was practically all of government boards, as I said, and the laws. The board saw its responsibility as largely dealing with administrative policy matters. Beyond that, it took the position, Madam Speaker, that the medical environment was a very specialized field, delivering healthcare services, and was required to enforce and operate within standards, procedures, and practices appropriate to the medical profession, which were outside the competence of the board to determine. Thus, there was clear separation of responsibility between the two. Doctors, as a rule, hold themselves to strict standards in their very unique professions, and the health practice law further prescribes standards and requirements. And this law was brought into existence by the then minister. And if one refers to Section 15, which I just read, it requires a health care facility to provide malpractice insurance for the registered practitioners practicing at a health care facility. And Section 27, which I just read of the law, specifically states that a practicing license shall not be issued to a registered practitioner unless the council is satisfied that the registered practitioner has adequate malpractice insurance from an authorized insurer approved by the commission. And they didn't put any limitations either. So I don't know how anybody would attempt to, even if he went that far, because I hear them saying about their limitations, but I don't know of any, because the law doesn't say so, if they got that far. However, Madam Speaker, Clause 12 in the Health Services Law may have been constructed. Certainly, it was never intended that the health practitioners at the HSA would be immune from negligence claims. This is supported by the fact, Madam Speaker, that the HSA has maintained medical malpractice insurance with the Medical Protection Society. So, Madam Speaker, there were no intention of legislators or government to exempt doctors of the HSA from liability of malpractice, and I don't think the minister held any such thought, and I certainly knew that there was no government policy to do so. So, Madam Speaker, later on I might have cause to withdraw my motion. I'm glad that the minister is moving this. If for no other reason, he thought he could beat me up real good. But the Hansard stands. They can say we passed it and it's been misinterpreted, but no one can tell me that I held any such thought or that I attempted to do any such thing, as all the legislation around us talks about the differences. Madam Speaker, when it comes to claims for medical, if the government is not mindful about doing anything about them, and we have had many over the years languishing and nothing goes anywhere, I took it upon myself as the then premier to settle at least 4 or 5 cases, and government paid them over a period of time. I believe that if someone is in need, and I believe that that need was caused by government, then government should stand behind them. In the case of Donna Thompson, I beg the cabinet to do the same. Take the case, look at it. If the child is what everyone says, I don't know that I know the family. Certainly I don't recognize the name, maybe by another name. But certainly from what is explained, then I would certainly do what I could to settle it, take her and help the poor girl and the child. That's what I ask government to do also. Thank you kindly.
Does any other member wish to speak or recognize the member from North Side?
Thank you, Madam Speaker. Madam Speaker, I rise to support the amendment to the Health Services Authority law that is before the House. From my point of view, I don't think that neither it was necessary to put either a indemnity or an immunity clause in the law at all. I can certainly attest that the 1991 Health Services law that I passed didn't include the clause at all. And Madam Speaker, while I support what the government is doing, I want to ask the minister to look at a few other things that I believe would help secure the situation on behalf of government. And part of the problem lies in the original construct of the law itself. Because it is normal, Madam Speaker, in healthcare institutions such as the HSA, that medical staff are separated and treated entirely different from what are termed employees of the organization. And one of the problems we have is that the current Health Services Authority law does not entirely do that. And it seems like an attempt was made in section 15.3c. And I'm not sure, I'm not a lawyer, but the way I read this, I think it eliminates the Health Services Authority and government from doing for their own staff. And I quote, Madam Speaker. Section 15 says power to employ staff. And 3 says the board shall also determine, C, the medical staff structure relating to registered doctors, dentists, and such other healthcare practitioners, and the professional qualifications, eligibility criteria, accreditation requirements and procedures, clinical privileges, and disciplinary procedures for such practitioners who are not employees of or under contract of services with the authority. And I believe the problem there is the not. Because I think it should simply say such practitioners who are employees or under contract of services with the authority. Because the way I read it, not means that the only people the board can apply this to are people who are not employees or who are not under any sort of contract to the authority. And I would like to invite the minister to look at it more carefully. Because, Madam Speaker, what the normal situation would be is that the legislation would say that the board would establish, whether they call him a chief of staff or a medical director, and it would insist that under the chief of staff or the medical director, the law allows them to and and they usually put in regulations what are called bylaws for the medical staff. And that lays out the structure, how you are, and you are normally only privileged to work in the institution according to your credentials or specialty. And because this law does not do that, it might be a consideration of the minister to add a subclause to clause 12 that says something to this matter, that a person appointed or contracted to the medical staff shall not, by reason only of such appointment or contract, be an officer, servant, or agent of the authority for any purpose, which would clearly put the medical staff outside of the authority, and then the authority can require that they have their own organization, their own bylaws, their own credentialing process, and part of that can be that they must have proper malpractice insurance and that they can be sued, because I think there's a section in the law that says the authority can be sued already. And Madam Speaker, the other fear I have of doing this is that it is likely to lead to a substantial increase in the payments to the Medical Protection Society for the medical staff at the hospital, because it is very likely that the Medical Protection Society was in fact had knowledge of that clause in the law. And I believe the last accounts I saw for the HSA, or the information I have, is that the last financial year the HSA paid some 2.5 million to the Medical Protection Society for its medical staff. Of course, Madam Speaker, the minister could also use Section 33 of the law, which allows the minister, after consultation with the board, to give directives to strongly suggest that it is time for the medical staff at the hospital, and maybe all of the medical professionals in the island, to look at setting up some kind of captive. I believe that Cayman is the leading place in the world for registering medical captives. I tried this back in 1989 with the Medical and Dental Society, and of course, that's a long time ago, and they didn't see the wisdom of it at that time. Had they set it up then, they would be in a very good position today, and none of this would have to be debated. And a good example they can look at, Madam Speaker, is what the state of Florida did, in particular under what they call NICA, which is Neurological Injury Compensation Association. And we know that birth-related neurological injury is one of the most expensive kinds of care, because it's going to be lifetime. And they set this one up, the Florida set theirs up in 1988. This is why I had the idea for doing it in Cayman, because I knew about this at the time. Because, Madam Speaker, just removing the immunity from the clause to allow people to sue the HSA directly for malpractice with for instance, yesterday we were an answer to the question, we were at 36% in cesarean births. And that in itself, Madam Speaker, is one of the reasons I believe that malpractice coverage insurance is so high, particularly for obstetricians, because it is usually accepted that under normal circumstances, a normal delivery is a lot less risky than cesarean section under anesthesiology. And I read with interest the criteria that was used in the answer to justify the high rate. But I speak subject to correction, but I believe the World Health Organization of expected cesarean sections for medical reasons is somewhere between 16 and 20%. Yeah, and what we got yesterday, the answer was 4 to 3%. I also know a little bit about this because I have developed a bad habit, some people say, Madam Speaker, of listening to other conversations while I talk. And while I was the member for health, it was at the Wharf restaurant actually, and I heard a friend of mine who represented one of the local health insurance coverages suggesting to the executive of the company who was here that of the women who had private health insurance with her, the cesarean section was 90+%. And I was dumbfounded. I went to her office the next day and apologized for eavesdropping on her, but she had the evidence. And most of that, Madam Speaker, was not medically related. It was two reasons: convenience for the patient and convenience for the doctor because they could plan the time of delivery, and there's also an economic value to it. Doctors get a lot more money from insurance companies or the patient for cesarean section than they get for a normal delivery. And these are the kind of things that contribute to the high cost of these malpractice insurances. And I have a genuine concern that if we don't put, as former governor used to tell us, belts and braces around this, by looking at some other aspects of the law and doing some innovative stuff, such as setting up a captive or some form of association to which all the doctors contribute and provide protection, I believe that the Minister of Finance might have reason to be worried about his 18-month budget, because there's the possibility that there could be a flood if some of the things that I hear about going on at HSE are in fact true. And Madam Speaker, so I would invite the minister to look at adding a subsection to what we're doing today, and to look at clause 15 in the current law, and to see whether we need to remove the word not or not, which would then, in my view, give the board the authority to insist that, one, there is malpractice insurance before you can be credentialed to work at the HSE, because I believe the word not eliminates them from doing that. And the board needs to have that authority, and it also needs to have the authority to insist that its staff is structured under proper medical staff bylaws, and that people are only privileged to practice at the hospital according to the credentials. And what that means, simply in layman's term, Madam Speaker, is that if I'm a board certified surgeon, I am privileged to work at the hospital as a general surgeon. I can't interfere with internal medicine or cardiology or obstetrics or gynecology. And one of the problems we have had in this country is that many of the board certified specialists practice beyond their board certification in other areas. And we need to make sure, because again, those are the kind of things that if the Health Services Authority Board is not in a position to require the medical staff to be properly organized and that they are only privileged according to their credentials, that is going to lead to more malpractice suits and is going to lead to increased costs of malpractice insurance. So, Madam Speaker, with those few comments, I support what's being done, but I believe we need to go a little further and do one or two more things, particularly to the existing law as it stands, in order to make sure that we can have the comfort as representatives that we're not simply here today creating a situation where people are going to start suing the hospital for every little thing and win because we haven't put the necessary things in place that will offer the protection in operation, which is likely to lead to less possibility of malpractice. Thank you, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak or recognize the Honorable Attorney General?
Thank you, Madam Speaker. Madam Speaker, I intend to be very brief. Just to say that I certainly do support the amendment to the bill to remove the immunity as it currently exists, Madam Speaker. The fact is that there are, as the Premier rightly points out, public policy imperatives which certainly dictate that a person who at least is making these allegations will have their day in court, have their claim adjudicated. There are also human rights imperative, Madam Speaker, which require that a person who again is alleging that they have been injured should at least have their day in court. And we just want to make it quite clear that by amending the bill as we're doing, nobody is saying that doctors are liable in any way. This will only simply allow for persons to have their claim adjudicated in the court. They will still have the burden of having to prove their case. So they will have to prove that there was a duty of care, which invariably there is. They will still have to prove that there was a breach of that duty of care by their healthcare provider. And they will have to also prove that the breach of that duty of care was what led to their injury, what lawyers call causation. So they still have that onus. And the amendment does not in any way seek to relieve them of that burden. But at least, Madam Speaker, they will have an opportunity to ventilate their claim in the court of law. Madam Speaker, the honorable member from Northside mentioned about captive, exploring the possibility of a captive. And I must say that is something that commends itself to me and something that has been discussed over the years with certainly some of the doctors here. I recall when we were having the discussions on the tort reform bill, we canvassed that possibility because they were complaining about, the insurers were complaining about the possibility of, not the insurers, some of the doctors were complaining about the cost of the premium. I think it was the OBGYN, especially the OBGYNs, and they always complain about it. And we suggested, Madam Speaker, that they might want to explore the possibility of having a captive. And I think their position is that the numbers tend to militate against that possibility. But I certainly don't share that view, Madam Speaker. I think, like the member from Northside, if they had been doing that over the years, it would have reached a certain level by now, where the premium or the payments that they would be required to make would be lessened. I am not so sure whether it's because of the transient nature of the society, why some of the doctors are not willing to participate in that. But I think it is still something that they should explore, Madam Speaker, given the almost prohibitive cost of these insurance premiums. The other thing I'd like to mention, Madam Speaker, is just to clarify that there is a difference between indemnity and immunity. And immunity basically prevents you from being sued. That's what it does. And I think maybe the one that comes to mind the most is diplomats, the diplomatic immunity. A diplomat can be charged rather for a criminal offense in the country in which he's posted. He enjoys immunity. But let's assume that the diplomat could have been sued, or can be sued, and there's a finding against him where he's required to pay damages. How an indemnity would work, Madam Speaker, is that instead of him paying the damages out of his pocket, his country would pay the damages out of public funds. In other words, he would be indemnified from having to pay out of his own pocket. So things like his legal costs, all his expenses, everything would have been picked up by his home country. And that's an example of what an indemnity is. But an immunity certainly works the other way. It prevents him from being sued or being charged for criminal offense. And certainly in the HSA law, that's the same sort of meaning it carries. It means that certain persons cannot be sued, of course, unless they are bad faith, which would include if you acted dishonestly and so. But assuming that you could be sued, then certain people like the directors and officers, they still enjoy what is called an indemnity. And that because they, as you heard, they are volunteers, and it was felt that the least government could do for them is that if they're volunteering their time, then the government should absolve them from any sort of costs, any sort of expenses, any kind of damages arising from any suit that might be brought against them while acting in the course of their duty. Again, of course, if they acted in bad faith, then they would be protected. And so there's ongoing debate, Madam Speaker, as to whether negligence is covered unless the language in the statute expressly says so. There are court cases going in both directions. One set of cases which says that even though the word negligence is not mentioned in the law, the assumption is that if you acted negligently, then you are not covered. There's another set of cases which says that unless the word is expressly put in there, then the assumption is that it is the other way. So the best way to provide certainty is to put the language in the legislation to make it clear that where you acted in good faith, then you're covered. But if there is negligence and it can be proven to the requisite standard, then certainly the persons who have been injured by that negligence ought to be properly compensated. And so, Madam Speaker, that is the extent to which I wish to contribute. I certainly understand that we don't wish to delve into the current matter. It is on its way to the Court of Appeal, I'm told. So we will await the outcome of that exercise. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other, I recognize the second elected member from the District of Georgetown.
Thank you, Madam Speaker. A few brief comments from me. As I publicly record my support for the amendment bill that's before the House. Madam Speaker, I think only fair to commend Premier and the Ministry and the Attorney General's chambers for the swift way in which they have reacted to the judgment that was rendered and the desire to deal with this issue. I recall several discussions that we had, and conclusion reached very quickly. It was one in which we had to deal with immediately what transpired and the outcome and the results of the judgment that was rendered by the Grand Court judge. But it was a very untenable situation, and was not one that which we sought to leave in place for any length of time. So I'm delighted that this evening we are debating these amendments that I think will remove that doubt and ambiguity, whatever it may have been, that existed, and make it clear that that professionals should not be able to be shielded by law from malpractice, and that those who are aggrieved or have been subject to the effects of a professional's malpractice deeds, that they should have their say in court and they should have their day. So I'm delighted to commend to this bill to this Honourable House and indicate my full support for it. Thank you, Madam Speaker.
Honorable Premier, we're just a few minutes from the hour of interruption. Is it your intention to conclude? I recognize the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I want to record my thanks to the members who have spoken on this important bill and offer their contribution to the debate. Madam Speaker, I sympathize with the Honorable Leader of the Opposition and who led the government at the time when this unfortunate provision was inserted in the law. And I'm certainly not intent on vilifying him or the minister or the government at the time, but it is plain that whatever advice they received at the time was not sound advice. And regardless of what it was that the minister or the government thought the effect of the amendment was or wasn't, it has been found and by the Grand Court, and indeed on plain reading to me, it is clear that the effect is to confer immunity on all employees of the Health Services Authority with respect to the discharge of their functions or duties, and that is sufficiently broad to catch doctors, nurses, and other healthcare workers. And so the intent of the change that this amending bill effects is to remove that immunity and to allow anyone who claims to be a victim of negligence of a health care worker employed by the Health Services Authority to be able to commence and pursue an action in negligence seeking damages before the Grand Court. And Madam Speaker, I have already set out, I think, in detail the advice the government has received with respect to this matter, and so I need not go through that again. I wish to thank the member from Northside for his support of the amendment, and we take on board his observations about the need to look carefully at the Health Services Authority law to ensure that there are not matters and issues there which will give rise to problems going forward now that the provision against immunity has or will be removed as a result of the passage of this amending bill. And so, Madam Speaker, I do not think I need to say more in terms of the wind-up, but to say again that the government has moved as swiftly as we have because we believe that it is fundamentally wrong that someone who suffers loss or damage or injury as a result of the negligence of another, that they should be debarred from being able to have their claim properly adjudicated and in the appropriate case to be able to be awarded damages for such injury, loss, or damage. And so, Madam Speaker, we have proceeded with alacrity to address an issue which has been brought to our attention by a finding of the Grand Court in February of this year. This is April. I don't know that government has been able to react as swiftly as this in respect of any other matter while fully meeting all of the constitutional and other requirements with respect to notice. So, Madam Speaker, the member from East End said we were so busy. He's absolutely right. We were so busy dealing with matters such as this. And so, Madam Speaker, again, I just wish to thank members for their support, and I look forward to a unanimous vote on the amending bill in due course.
The question is that a bill shortly entitled the Health Services Authority Amendment Bill 2016 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. I recognize the Honorable Premier.
Madam Speaker, may I have a division, please?
Madam Clerk, please call a division.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell.
Aye.
Honorable Kurt Tibbetts. Honorable Osborne Bodden.
Aye.
Honorable William Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers.
Aye.
Mr. Roy McTaggart. Mr. Joseph Hugh.
Aye.
Honorable McKeeva Bush. Mr. Barney Bush. Captain Eugene Ebanks. Mr. Alva Saku.
Aye.
Mr. Winston Conley.
Aye.
Mr. Ezra Miller.
President, sorry, yes.
Mr. Arden McLean.
Aye.
Honorable Anthony Eden.
The results of the division are as follows. 16 ayes, 1 absentee. The motion is carried. I recognize the Honorable Premier for the adjournment motion.
Thank you, Madam Speaker. Madam Speaker, I want to thank members for the dedication to the work of the House this past week. We've really made great progress, and I wish everyone a wonderful weekend and move the adjournment of this Honorable House until Monday morning at 10 a.m.
The question is that the Honorable House be adjourned until Monday at 10 a.m. All those in favor, please say aye. Those against, no. The ayes have it. The House stands adjourned until Monday, 10 a.m.